to please light the lamp so that we can start on an absolutely auspicious note. We are greatly privileged to have Mr. Rajiv Kher, who is the member of the Competition Law Bar Association with us. And of course, on this wonderful note, I'd like to request them all to please come forward and light the lamp. We have Mr. Atul Dua, and could we please begin with Mr. Ramji Srinivasan, who is the President of the Competition Law Bar Association. Shubham Karoti Kalyanam. We fold our hands early in the morning to begin on an auspicious note, lighting a lamp to signify that all that we do must be guided by the purity of this fire, of this lamp that is being lit by these very special luminaries of the legal profession. As the lamp is lit, to continue the morning in a spirit of appreciation, I'd like to request Mr. Ramji Srinivasan, Senior Advocate, President, Competition Law Bar Association, to give a bouquet of flowers to Justice A.K. Sikri, to thank him for being here with us and making this occasion very, very special. I'd also like to request Mr. Karan Chandyok, who's the Treasurer of the Competition Law Bar Association, and in his absence, I'd like to request Mr. Atul Dua, who's the Honorary Secretary of the CLBA, to please offer a bouquet of flowers to Mr. Rajiv Kher, member of the Competition Compat. And I'd also like to request Mr. Atul Dua to welcome Mr. D.K. Sikri with a bouquet of flowers. May I request Dr. Vijay Agarwal, Vice President, Competition Law Bar Association, to welcome Dr. Abhishek Manu Singhvi with these colorful, cheerful flowers that make the morning absolutely bright and welcoming. Thank you so much. May I request you all to take your seats, and I'd like to request Mr. Ramji Srinivasan, who is a Senior Advocate of the Supreme Court, and I think once he realized that there were going to be these complex regulatory laws, he decided to specialize, and with 24 years of specialization, it's not surprising that whether it was telecom, broadcasting, energy, aviation, oil and gas, or even competition law, he is the master that many refer to. Not only has he successfully presented for several private clients, but has also represented the Competition Commission of India, both at various high courts as well as at the Competition Appellate Tribunal. So ladies and gentlemen, I'd like to hand over to the President of the CLBA to take this conference forward.
Thank you very much, Yuvani. Honorable Justice A.K. Sikri, Judge, Supreme Court of India, Honorable Mr. Rajiv Kher, Member, Compat, Honorable Mr. D.K. Sikri, Chairperson, Competition Commission of India, Dr. Abhishek Singhvi, good friend first, Senior Advocate and Member of Parliament, Mr. Dua, thank you very much for accepting our invitation to join us this morning at the 3rd Competition Law Bar Association International Conference held at Delhi in these August premises. I know all of you have your busy schedules, but I'm truly grateful for accepting. On behalf of the Competition Law Bar Association, I welcome you, sirs, to this conference. I also welcome the distinguished guests, including Honorable Ms. Kapoor from COMPAT, who is here at our invitation, honorable members of the Competition Commission, Mr. Mittal, Mr. Peter, Justice Mittal, and all my friends from India and abroad who've all come and accepted our invitation to be here. I also must thank the members who have contributed to the souvenir that is going to be released today, and also the efforts taken by all the young lawyers who have made this possible. Competition law, though enacted in 2002, actually got its teeth in 2009. It is almost 7 years today that we have the Act in place, and we have seen a huge impact that the Act has made through the offices of and the untiring efforts of the Commission in paving the way, in making sure that its objectives and its functions, not only through advocacy, but also through enforcement, finds resonance in the economic affairs of this country. It's an economic legislation. It is a very powerful legislation. It vests the Commission and also the Appellate Tribunal with huge powers, including powers of divestiture of the companies, breaking up of companies, apart from the penalties that can be brought in for infringing the provisions of the Act. This is a good time for us to evaluate the progress that has been made by us in the Indian context especially, given the socio-economic context in which India finds itself. Although about 123 countries across the world have embraced competition law, but each of the acts and each of the legislation in each country has to be obviously enforced in accordance with the socio-economic situations that obtain in their jurisdictions. The Commission has, of course, also tied up as part of the International Competition Network and has also participated in various international cooperation agreements. Over a period of time, we as members of the Competition Law Bar Association have found that the decisions in this respect and the various steps taken by the Commission are in recognition of the Indian context, and therefore while we will evaluate in the various sessions that you will find today and debate in the various intriguing sessions that we will have with participation from Indian as well as foreign lawyers, also sectoral regulators who are also going to participate in each of the sessions has been designed today with great interest and special focus on what are the nitty-gritties of the competition law. This is a conference that is for the lawyers, by the lawyers, and certainly will be debated amongst lawyers. This is not the usual conference where you have the industry or a commercial sort of a thing, but this is an evaluation that the bar has actually taken to ensure that there is interaction between, and usually we speak to ourselves, but here is a wonderful moment with the cooperation of the Commission, with the cooperation of the COMPAT, whose blessings we have as the third pillar that we have, if I may take the liberty, sir, and the encouragement that both the COMPAT and the Commission has encouraged the bar with the involvement. We are grateful and thank you. And with these opening remarks, I will therefore proceed to sit down and listen to everybody else on the dais. Shivani will now take over and ensure.
Thank you so much. And as we know that a level playing field is what we're here to create, is what we're here to sustain, because this is not something that can ever be taken for granted. Even a farmer's land has to be tilled and leveled out, whether it's a tractor or it's the equipment that they use, which may be more manual and more prevalent in our country even today. Similarly, in a competitive global environment, we do need this body and this body of people who ensure that the playing field is level. And today we are greatly privileged at the 3rd International Competition Law Conference to have 10 foreign members as well. I'd like to welcome you all. And of course, as Ramji said, that there is this publication by Manu Patra, where for the first time we're going to have the Competition Commission of India and the CLBA logos together. It's a joint effort by many, and it's a great privilege to have this occasion to release that later today. For now, I'd like to request Dr. Abhishek Manu Singhvi to please deliver the opening address. As you know, he is, of course, a senior advocate, the spokesperson of the Congress Party. He has been a member of the Rajya Sabha, the former Additional Solicitor General of India. He has been a member on several committees that have shaped the course of the country, and it's a great privilege to have you, sir. I hand over to you.
Justice Sikri, Mr. Kher, Mr. D.K. Sikri, the midwife for this organization, Mr. Ramji Srinivasan, Mr. Atul Dua, Madam Kapoor from the Compat, honorable members of the CCI, distinguished members of the legal fraternity and of this very elite bar, the competition bar, ladies and gentlemen. When I received the invite for the inaugural session, I was struck by the ingenuity of the organizers in drafting it. To be accommodative and inclusive, they have traveled, and although we have some abstentions, in conception they traveled from a welcome opening address to an address, to an opening address, to a keynote address, to a special one, and then finally the inaugural one. Now you know why competition lawyers are so clever. Unfortunately, at one time it increased my jurisdictional problems, although they are lessened now because there have been 2 dropouts I see now. Because originally I had to figure out how to open an inaugural session without giving a mere address, nor an unwelcome one, avoiding the keys and the notes which the chairman of Compat might hit, not overlap with any special features of the special address, and naturally steer clear of the inaugural address. All this tightrope walking in 15 minutes is a pretty difficult task, but let me start. Let me start by saying that we must all be collectively self-congratulatory to see how much greater acceptability competition law has, and how far, remarkably how far, we have traveled from the days of that icon of individualism and objectivism, Ayn Rand, when she wrote in 1962, and I quote, "The antitrust law, an unenforceable, uncompliable, unjudicable mess of contradictions, has for decades kept businessmen under a reign of terror. Yet these laws were created and to this day are upheld as a grim monument to their lack of political philosophy, of economic knowledge, and of any concern with principles. There is only one difference in the legal treatment accorded to a criminal or a businessman. Namely, the criminal's rights are protected much more securely and objectively than the businessman's under competition law," unquote. And many others, mind you, contemporaneously and even earlier, echoed this sentiment. Isabel Peterson, who wrote frequently, called it a freak legislation. She said, quote, "As freak legislation, the antitrust laws stand alone. Nobody knows what it is that they forbid," unquote. Such doubters would doubtless now be turning over their graves if they saw the universality of competition legislation and the glory of regulators and adjudicators in these differing jurisdictions of differing shapes, sizes, and hues. And the chairman CCI just told me a minute ago that over 130 countries have established embedded paradigms. So we have traveled far, and it is therefore an occasion for collective self-congratulation. Secondly, a word on what should be some of the animating approaches of such regulatory adjudicatory bodies. One clearly, according to me, should be that law, as indeed life, is all about balancing competing values. Those values range from competition virtues, of course, to IPR pulls, to consumer interest pressures, to longer-term national interest considerations, and so on. In all this, we must therefore remember that the Aristotelian virtue always lies in the middle, between two extremes, each of which is a vice. We must therefore hearken back to what the comedian, who later became a US senator, and I didn't say president, I said senator, Al Franken said, quote, "Antitrust law is not about protecting businesses from each other, it's about protecting competition itself on behalf of the public." Those are the mainstream animating themes, but we must not forget the more boundary, some call it the fringe boundary limits as well. Warnings from persons like deceased US Justice Scalia, who, though a right-winger, was not wrong according to me when he said, "The mere charging of monopoly power may not be unlawful. Instead, it may be an important element of the free market system itself. Monopoly prices, especially in the short run, may attract business acumen in the first place. It induces risk-taking that produces innovation and economic growth," unquote. These are two or three diverse, some mainstream and some fringe animating approaches, which I think all adjudicators and regulators would do well to keep in mind. Thirdly, I think that future exciting areas of growth are likely to be the intersection of IPR and competition issues. Section 3.5 largely gets it right. Firstly, by letting CCI be the arbiter of what is a reasonable condition imposed to protect IPR. Secondly, by predominating IPR as far as Section 3 is concerned, but by simultaneously subordinating it as far as Sections 4 and 5 are concerned. And also by generating jurisprudence which is far more complementary and converging of these two areas than conflicting and diverging. Another desirable trend has been to emphasize the dual character of IPR rights themselves. For example, in copyright cases, the principle that even more important than ensuring a return to the copyright holder, or for that matter, in a patent case to a patent holder, is the vital necessity to stimulate artistic work for public good. And if conflict becomes inevitable, the latter must prevail over the former. In the Nintendo case, I think the competition IPR intersection was well put. They said the aims and objectives of patent and antitrust laws may seem at first glance wholly at odds. However, the two bodies of law are actually complementary, as both are aimed at encouraging innovation, industry, and competition. Fourthly, while there are those who criticize or may criticize, cavil or crib at what is characterized as an overly technical or legalistic approach of compat, I think that these involve vital constitutional safeguards which are mischaracterized as procedural or technical. Virtually no other statute permits the humongous deterrent penalties which are contemplated by the Competition Act. I know of none in India at least. While we are so jealous of criminal law rights and safeguards, every day we know, from the trial courts up to the Supreme Court, how can we apply alien and different standards to a process merely because it's called competition law? It shares so many features of criminal law. And there are lots of jurisprudence now growing in Europe. I know you haven't accepted it here fully. But it was best put by an Advocate General, Sharpston, in the 2011 KME Germany case. And I'll just quote that. He said, "The procedure whereby a fine is imposed falls under the criminal head of Article 6 of the European Convention of Human Rights. The prohibition and possibility of imposing a fine are in legislation of general application. The offense involves engaging in conduct which is generally regarded as underhand and to the detriment of the public at large, a feature it shares wholly with criminal offenses in general and which entails a clear stigma. A fine up to 10% of annual turnover is undoubtedly severe and may even put an undertaking out of business. And finally, the intention is explicitly to punish and deter with no element of compensation or damages," unquote. Now, friends, if that makes enforcement of competition law quasi-criminal, not only all forms of natural justice And remember, natural justice in India has been elevated to the status of Article 14 of the Indian Constitution. But diverse other safeguards, and most importantly, the countervailing obligation of extra care and caution by adjudicating bodies is activated. Pragmatism, I know, may dictate that the beyond reasonable doubt standard of proof may not be feasible. And I believe Compat has held it 5 days ago again in the GSK case. But classic principles of criminal law regarding legal certainty, prior declaration of rules, guidelines and principles to judge and to quantify such humongous penalties, the rule against retroactive effect of penal charges, and even the rule against double jeopardy may someday have to be applied in competition cases. Incidentally, the double jeopardy rule has already arisen in European jurisprudence, though it was distinguished and not actually applied. But in principle, the quasi-criminal nature of these proceedings in the competition arena has been accepted in European jurisprudence, in the Menarini case, in the soda ash Solvay case, and so on. The strict thresholds, therefore, required for collusive behavior, one of the examples happened 5 days ago recently in a Compat judgment, where strict thresholds were prescribed, must be viewed in the context of this quasi-criminal character or nature of the very theme. Otherwise, there was a time in the old days when behavioral norms led to inferences much more easily. I remember Adam Smith's quote, which was applied for those behavioral norms, and he said, quote, "People of the same trade seldom meet together even for merriment and diversion, but the conversation always ends in a conspiracy against the public or in some contrivance to raise prices," unquote. That obviously will not be enough, as the Compat reminded us 5 days ago. Fifthly, it is in that context that I welcome greater and more expansive review of even DG reports and processual approaches by the Director General, in turn reviewed by the Compat. A DG in theory is not an adjudicator, perhaps not even a quasi-judicial body. But the DG report wields immense influence and weight at a very early stage of the proceedings, and in practice makes or breaks most cases. Its commitment to processual justice, coupled, and I emphasize coupled, with comprehensive compact review, becomes a vital safeguard in this chain of what are called fairness controls. Sixthly, I am mystified as to why multi-product or multi-activity entities continue to be penalized on gross aggregated turnovers, well beyond the narrower vertical where anti-competitive behavior is complained of, despite, I believe, Compat's clear directive to the contrary as far back as 2013 in the phosphate case. Also, a little notice, but a vital principle which we must develop in the years to come, mentioned somewhat a few months ago in another ITPO decision, that dominant undertakings cannot be expected to support or subsidize nascent or weaker rivals, is a theme of great significance. After all, competition law is not a promoter of charitable or unnatural conduct. Conduct where entities are required to act to their own detriment to support or give breaks to a trade rival. Seventhly, while CCI is doing its bit for advocacy under Section 49, it needs to do much more to embed the letter and spirit of this subject in the hearts and minds of the people of India. The same Al Frankener, the comedian who became a US Senator, underlined the forbidding, mysterious, ivory tower nature of competition law when he said, "Most Americans don't think about antitrust law when they look at their cable bill, flip channels on TV, or worry about what their favorite website knows about them. But they should. And that should will happen more and more when you invoke, use, and expand Section 49. For example, the UK competition authorities have published a guide for startups. And they did that after a statistical survey showed that even in UK, there were very low awareness standards of what is anti-competitive. Eighthly, the second aspect of Section 49, which is found in 49.1 and 2. 49 is an interesting provision where the marginal note only refers to 49.3, but 49.1 and 2, which are not referred to in the marginal note, empower state and central governments to seek, as it were, an advance opinion not an advance ruling, but an advance opinion from the CCI on any issue regarding competition implications. And that's a good thing. I don't know how many times it's been used. But the response of CCI should not be liable to be ignored, as presently under 49(1) and 2 it can be. And perhaps the analogy of the TRAI Act should be used, that if you don't act on it, you must give reasons in writing, which in turn would be reviewable. And that amendment should be made, I think. Ninthly, given the size and importance of the Indian generic pharma industry, I noted with surprise that, to the best of my knowledge, Indian cases involving pay-for-delay paradigms, an interesting new development. Pay-for-delay paradigms are where an entity pays a competitor to delay that competitor's launch of a product, thereby maintaining the paying entity's near monopoly status. So it's interesting how, with the huge significance of the generic pharma industry in India, this line of a lawyer's delight and an adjudicator's nightmare has not yet started. But I'm sure there is happy news for all of you around the corner. Tenthly, in sections 3 and 4, some argue that there are lacunae to be filled. For example, that there is no mechanism under the Act for without prejudice settlements. That may not be correct, I think. This ignores the vast regulatory discretion of the CCI. For example, it could ask firms to change their conduct on a without prejudice basis and then decide that there is no need to further proceed or no need to intervene. This would help create a culture of compliance rather than merely excessive fines. 11th and last. I'm sorry, it's not last, but I'll be within my time, I promise you. 11thly, I respectfully disagree that an amendment to the Act is required to assess the effects in abuse of dominant cases. Some people believe an amendment is required. The entire framework of the Competition Act, from the preamble onwards, clearly requires an effects-based analysis. Compact has so signaled in some judgments. I believe in some judgments the CCI, Hockey India, for example, even before the Compact, has accepted that you can, under the existing Act itself, have a full-blown adjudication of the effects doctrine. And I think that is central to the theme of competition adjudication without waiting for any clarificatory amendments. Last, friends, we must remember the eternal paradox between the condescending, patronizing, barely tolerating view we have of competition in the individual and the personal arena versus the excessively elevated virtue given to competition in the marketplace. A divergence which has never ceased to amaze me. As a very well-known writer, Alder, put it, quote, I am convinced that the jealous, the angry, the bitter and the egotistical are the first to race to the top of the mountains. A confident person enjoys the journey. The people they meet along the way and sees life not as a competition. They reach the summit last because they know God isn't waiting at the top, waiting for them. He's down below, helping his followers to understand that the view is glorious wherever you stand. This is a very interesting paradox between how high we place competition in the marketplace and how low we place it in personal life. Thank you very much.
Thank you so much, Dr. Singhvi. Thank you for taking us into your candid corner. It really felt that we had gone into your reading list, your experiences, and of course your legal journey. And as you all know, he used to write the Candid Corner in Hindustan Times, and this was published later as Candid Corner Reflections by Dr. Abhishek Manu Singhvi with a foreword with the then Prime Minister. He also wrote in the Dainik Bhaskar, the largest Hindi daily, and reached out to many, sharing the knowledge and pearls of wisdom that he gained over the years of experience that he's had in the legal profession. Thank you for the sharing. I would now like to invite our keynote speaker, Mr. Rajiv Kher, who is a member of COMPAT. He was the former Secretary Commerce. He is from the UP cadre of the IAS. And we're greatly privileged to have you here with us, sir. Please share your words with us.
Honorable Mr. Justice A.K. Sikri, Chairman, Competition Commission, Mr. D.K. Sikri, Dr. Abhishek Manu Singhvi, Mr. Ramji Srinivasan, Mr. Atul Dua, my colleague Mrs. Kapoor, distinguished ladies and gentlemen. At the outset, let me thank the CLBA for giving me this opportunity. though I recognize early in my baptism in this line of business, I heard a phrase called proxy counsel. And I realized that, yes, I am a proxy counsel today because I am, in a sense, here to fill in for my chairman, very distinguished person by himself. But normally the poor proxy counsel ends up making an application for adjournment or, for some odd ground which he often gets rejected. I don't know about rejection, but I am definitely not going to make a small application. I'm just going to share some thoughts with you on how I have perceived the competition law and its application as it stands in India. Having come from a background of trade and commerce, having worked there for a significantly longer time, I do recognize that this looks like an extension of what I was doing. And therefore, I find quite familiarity with particularly the business dimension of the kinds of issues that come before the compet. The due process dimension was obviously not familiar to me, but having come to compet, I recognized the relevance and importance of the dimension. And as Dr. Singhvi very rightly said, in my view, if a sustainable architecture has to be created for competition implementation in this country, then the due process dimension has to take sound root in this ecosystem. And that's what, in a small way, Compet has been trying to contribute in the last couple of years. But I don't want to lay more emphasis on that because it has already been very ably put forth by Dr. Singhvi. In a slightly broader context, competition, as I said, is an extension of the ecosystem that I was dealing with, trade and commerce, and also has a very close relationship with this whole drive towards globalization. Despite the short setback to globalization which we see in the UK and now the US, I don't think anybody will disagree with me that globalization is something which is there to stay. We are not seeing any reversal in the near future. And the manner in which we have embarked upon building up our economy, globalization is an intrinsic part of the process of growth for us. While we offer a huge consumption platform for businesses and industries by virtue of a large population that we have and the growing middle class that we have, globalization is an imperative because the factors of technology, the factors of business processes, the factors of efficiency, all of these trickle in as you globalize in value chains, as you globalize in services. And therefore, competition law and its enforcement in this country is come to take sound roots. No wonder in 7 years of effective implementation, we have seen a significant amount of evolution of jurisprudence, both on process and substance. And from the panorama of litigation that we face, we can very well see that a lot more is to come. Now, for a competition regulator, it becomes an extremely difficult task to set that balance between what technology and business practices offer by way of challenge, and on the other side, the consumer welfare, which essentially drives the whole process. And therefore, the role of the competition regulator, in my opinion, is extremely difficult, much more difficult than possibly in any other sectoral regulator. It is also at the same time very important that some kind of a balance between sectoral regulators and competition regulators is recognized sooner in this course of journey than later. Competition as an important discipline is also a multidisciplinary discipline and therefore has elements of specialist knowledge, expertise, and to that extent is quite significantly different from a traditional legal pursuit of an objective or a cause, which transcends through the process of judicial examination. And therefore, I think there is a big role for the expert community, for the specialist community, which often the regulators and judicial institutions may shun from utilizing. There are intrinsic apprehensions because you never know whether expert community is biased for expected reasons, or whom do you call an expert? If you have a specific issue, how do you recognize somebody as an expert? Somebody may be visible, but is he an expert? Somebody may be on television every other day. Somebody may be speaking in conferences, but is he really an expert? And therefore, I think the choice becomes very difficult, but the fact is that, yes, it is important that we need to infuse our work with a lot of specialist understanding. And this is not true only in the context of economics, it is also true in the context of technology. It is also true in the context of the manner in which businesses are transforming these days. The organizations, as we all know, are becoming flatter. The manner in which services are delivered, the entire vertical system, the vertical chain is becoming flat. The producer or the deliverer of service is wanting to reach the consumer directly. And therefore, you have a huge internet platform which has come up. In sector after sector, you see delivery of services and products utilizing technology and the internet. And therefore, the regulator's task is becoming even more difficult, and the stakeholder community, of which the legal community is one part, also faces this challenge of developing understanding and specialization in this area. Now, it is also in this context important as to at what point this technology-driven efficiency seeking transforms into an abuse of dominance situation or a predatory situation, abuse of dominance. And I think, therefore, this big challenge before the regulators and all of us is to recognize that ultimately driven by consumer welfare, but at what point in time it starts impacting competition adversely. So this balance between what the consumer wants, what the technology offers, what the law provides, and how to find a balance between all of them to benefit the ultimate consumer, but at the same time recognizing that it is not out of, because if it is out of abuse of dominance, then clearly either the law is deficient or the regulatory practices are wanting. Now, as we globalize, as we integrate more and more with the global businesses, more and more investments will come into India, and we are already in the present gloomy international business context are one of the bright stars. More and more investments are expected, and therefore expectation of entities who make investments to find level playing fields, to find a competitive environment will be increasing. Now, this is also a challenge because this offers us an opportunity to address the whole issue in an upfront manner, but at the same time, there is a large chunk of businesses and entities which are actually not yet adequately informed of the importance of the good and the bad of competition. There is an inbuilt tendency towards protectionism the moment you start talking of competition. And to what extent our advocacy efforts are percolating the understanding of competition philosophy is, I think, very important. Therefore, small businesses, small institutions which are in the sense of sectoral institutions. Every other day we see a case which is driven by the elements of competition law, but actually at the end of it, you realize that there is hardly any much competition issue involved, but it is more of a sectoral issue. So I think this becomes very important that we educate and we do the advocacy for those people who are ultimately going to benefit out of this. I had earlier said about the elements of technology. We also need to recognize that more and more new methods of creating the dominance and then using that dominance for making gains or eliminating competition are being done. My experience of trade and commerce clearly shows that this whole plethora of private standards has come into businesses. There's nothing wrong with private standards. But private standards, when they start eliminating businesses, are a big challenge. We don't have a solution on the side of the WTO because the technical barriers to trade agreement doesn't address this issue. But as a matter of fact, there is no solution to private standard in a multilateral context yet. And therefore, we will have to see to what extent these solutions can be found in antitrust law, in developing countries particularly. I was expected to give a keynote address, but I deliberately avoided doing that because I don't think I can fill in for Justice Singhvi, so I don't think I should be delivering a keynote address. I've shared some of the thoughts that I thought were relevant for me. A couple of points before I conclude. Presently, we have a case-by-case approach towards dealing with issues. Now, clearly, the Commission gets saddled with a whole lot of such information, stroke complaints, and spends a lot of time, a lot of precious time of itself and the entire stakeholder community which is involved with that. We clearly, the country clearly, or the government clearly has a national vision and has a priority in that national vision for various sectors, for various kinds of economic pursuits. And therefore, it offers us a significant possibility of creating some kind of a prioritization, some kind of a selectivity towards what do we want to deal with in the first instance. Secondly, it is not always possible to decide a pan-sectoral gamut of issues on the competition law. And therefore, though the trigger may be a case, but can we use this opportunity to take a pan-sectoral view for deciding competition issues that are involved in that sector and issue a guidance? Now, in India, we have not done yet, as far as I understand, of issuing sectoral guidance. Is it possible? Because personally, I feel that if we have a clear visualization of what are our priorities, and if we have a clear understanding that these sectors require a certain amount of element of competition to be infused into it, then I don't think it should be very difficult to look at a pan-sector approach and see how this guidance can come out. Because sector by sector and then going through the process of judicial reviews and so on, we may end up creating complicated and complex and conflicting decisions over a period of time. It's 7 years down since the effective implementation started. And I think it's also a time to evaluate and to see how various sectors have actually benefited by what we have done in these 7 years. We have litigation coming out of specific sectors, and I think there should be it should not be difficult for us to create an evaluation and to see exactly how these sectors have benefited out of what we have done. I think I would like to stop here. A last point on the amendment to the law. Well, to be honest, I am not a legal expert in that sense. I have not really looked at the law in the sense of reforms, in the sense of revision. But I do feel that the regulations which govern the processes, do require a review. And maybe the Commission would like to look at that. Thank you very much once again, and let me thank CLBA for giving me this opportunity of being here and filling in for Dr. Singhvi. I am indeed grateful to the CLBA. Thank you so much.
Thank you so much, Mr. Kher. Justice G.S. Singhvi and the members of the COMPAT are a team, and you have shared and put forth the vision of this team, and that is greatly appreciated. Dr. Singhvi said the first step when he talked about Ayn Rand and quoted that how criminal law had at once upon a time more focus. It's like the problem child at home. The parents end up spending more time, energy and resources to mainstream that child. But that does not mean that you ignore the child who carries forth the values and the sentiments of the family. So hence the competition law and its significance. And of course this significance carries forward not just to the companies that are creating an environment to function well, but also very importantly the consumers. So on this note, I'd like to invite our very esteemed guest for the special address, that is the chairperson of the Competition Commission of India, Mr. Devinder Kumar Sikri. Mr. Sikri was formerly an Indian Administrative Services Officer of the Gujarat cadre. He has, of course, he superannuated as Secretary, Department of Justice. He was Secretary, Department of Women and Child Development. He was the person working very closely with the census, and of course, he was the collector of Jamnagar. So many spheres of working, and now in his role as chairperson of the Competition Commission of India, he is able to take forth all this experience. Today we greatly miss Mr. Dua, who was formerly part of the CLBA, and on behalf of the CLBA and all the people present here, thank you, sir, for being with us, and may I hand over to you.
Thank you. Honorable Mr. Justice A.K. Sikri, Judge of the Supreme Court, Mr. Rajiv Kher, Member of COMPAT, Dr. Abhishek Manu Singhvi, Senior Advocate and Member of Parliament, Mr. Ramji Srinivasan, Senior Advocate and President of the CLBA, Mr. Atul Dua, my colleagues from the Competition Commission of India, Member Appellate Tribunal, COMPAT Anita Kapoor, friends, distinguished ladies and gentlemen. After Mr. Abhishek Manu Singhvi, I think you feel really intimidated, because the Competition Commission, through COMPAT and through the eyes of the various advocates who have seen the law more than a person standing before you now, one gets the feeling as if we are, the Competition Commission is there to receive both the bouquets and the brickbats, as Ramji said just now to me. Well, we don't mind that, and we are not averse to it, because the process starts with us, the Competition Commission. And it's the first stage, so naturally there will be levels at which the decisions or whatever we do will be looked into, commented upon, and we always look forward to such a guidance, both from the institution which are above us, the COMPAT, and later, of course, the High Courts and Supreme Courts, as well as from the outset. And to that extent, I think the CLBA needs to be complimented for organizing this event today and for inviting us. I must congratulate you for conceiving this conference and for giving it the shape. As far as the Competition Commission is concerned, we all know how it came into being, and it went through a process. But finally, as Mr. Singhvi said, the actual operation began from 2009 onwards. Without getting into details of the reason which caused the delay between the setting up and its actual commencement, all I would say is that the Commission has been working since then very assiduously to meet the objectives which have been laid out in the law, and trying to see that the markets, they behave competitively and the stakeholders are better off in the liberalized economic scenario. The Parliament, while amending the law, also provide for the oversight body like COMPAT, and the filter they have created through the COMPAT has been very greatly helpful to us, and they're working in tandem with the Commission. And I must say that this has greatly facilitated the working of the working of the Commission in implementing the law. As in other jurisdictions, the Commission passes remedial orders in Sections 3 and 4 and also accords approval for merger and acquisitions under Section 5 and 6 of the Act. In the last 7 years of its work, we have registered over 800 cases and have passed final order in over 600 cases. The Commission directed investigation in over 350 cases. But over the year, the percentage of investigation orders have been steadily declining. Let me say in the last year, 80% of the cases we passed orders for closure at the prima facie stage, which suggests that the threshold at which the Commission is now adopting with experience for assessing the anti-competitive behavior is improving and is growing in stature. In merger reviews, out of 500 merger notifications, more than 99% have been approved without modification and within the stipulated period laid down in the law. Now, competition law is not a simple law. It's a mix of law and economics applied to the markets, and that to markets of 21st century, which are becoming more and more dynamic. Its application requires substantial legal and economic analysis, and those working in the Commission, they have to constantly keep pace with the ever-increasing changes in the industry and economic landscape. During the international events, we have observed that even the mature jurisdiction, having decades of enforcement experience, they are grappling with some of the very complex issues and in the emerging new markets. Young jurisdictions like CCI, they are not an exception. They also are struggling. One of the common challenges before all the competition authorities, which emerges from these conferences, is the digital markets as well as the disruptive technologies. They're all engaging our attention, and understanding of the issues arising from them are being addressed internally as well as in international meetings. Along with, Commission has been continuously streamlining its procedures through amendments of its regulation and making processes more and more stakeholder friendly and to bring greater transparency. In our journey of implementing the Act, legal fraternity as well as the Competition Law Bar Association have played a very vital role. We are indeed very happy and to see a very responsible and very responsive competition bar emerging and evolving in the country in such a short time since the commencement of the enforcement of the competition law. Working together, we are seeing jurisprudence emerging gradually, and we expect this to be consolidated further in the days to come. Along with all this, along with some of the insights, dissections provided by eminent persons like Dr. Abhishek Manu Singhvi, I'm sure would help in effective implementation of the law in the country. Let me take this opportunity to just touch the point which he made about penalties. No doubt, penalties attract attention. I mean, this is something which is very easy. But Commission, I have always said, and I repeat, we don't favor penalties. We enforce them only when they become a must. But I must also say that the penalties are levied keeping in mind their proportionality. They look very big at times, but if seen against the public harm for which the tools and the methods have yet to develop in this country is seen along with, they may not look as dangerous as they tend to look at times. We have seen a jurisdiction where claims are filed for damages, and that is a measure of the public harm. But so far, I mean, though there is a provision in the law we have, but this is not happening so far in the country. We expect this to grow, and I'm sure if that happens, once that happens, the penalties may look very, very reasonable and proportional. Friends, today markets are global, and because of the extraterritorial jurisdiction of the Act, we need to keep abreast with the development taking place not only in our country but across the world. After assuming office, I've attended few international events, including the ICN at Singapore last year, in 2016, this year. I find that the non-government agencies, they have a very important role to play and work with the respective competition authorities to produce work products and papers. They have been very active in these conferences, even in the technical session. We see in the Commission, we see a lot of synergies in the work of the competition authorities and the non-government agencies. We shared this, discussed this in the Commission, and now we have decided to nominate non-government agencies on behalf of the CCI from 2017 onwards. The Commission has taken this decision after engaging with stakeholders and has shortlisted 7 law firms and 2 organizations, including CLBA, as the non-government agencies for the next conference. The individuals from these firms' organization would be nominated by rotation for the ICN annual conference and for the workshops for the working groups of the ICN. While speaking of the International Competition Network, ICN, I'm sure by now you must be all aware that the ICN 2018 will be held in India. With this, CCI becomes a member of the steering committee of the ICN for a period of 3 years. In this scenario, all our NGOs will need to very actively engage with us and work with us for preparing the ICN 2018. The CLB is already associating with CCI in preparing a competition compliance manual, and we are hoping to see an excellent work product in the form of a manual soon. We expect that this will be very useful and provide guidance to corporates and stakeholders in improving competition compliance in the country, which we are, of course, addressing through a lot of advocacy programs. And to tell Mr. Singhvi, we are doing our bit, and in the last 6 months, about 66 programs have been organized. We are trying to reach out to every possible stakeholder, be it industry, be it business association, industry association, universities, law schools, whosoever is connected with the competition law. I think we are trying to reach out to them. And I was very happy to hear yesterday when somebody rang me up that, that Mr. Birla has taken some 160 professionals to Dubai for a training in competition law. And he has called some eminent speakers to talk to them. That's very encouraging. We also believe that competition compliance is more important than competition and the enforcement of the law. The agenda of conference is touching on the very right topics, and I'm sure they will be very engrossing with the very able speakers from the judiciary, from the bar, and the competition authorities. I will wish the conference a success, and I'm sure that the technical session would highlight and unfold global perspectives along with the evolution of Indian jurisprudence, that is, as it has taken place, and there will be substantive takeaways at the end of the event. I request Mr. Ramji Srinivasan and the host to share those outcomes with us so that we also take things forward and work more for the benefit of the consumer and for the economy as a whole. With these words, I conclude, and I wish you all the best, and thank you very much for inviting us. Thank you very much.
Thank you so much, Mr. Sikri. So the compliance manual is next on the agenda, but for now we have a Manupatra publication. But before the publication, it would be a great privilege and honor to have the Honorable Justice of the Honorable Supreme Court of India, Mr. Arjun Kumar Sikri, to deliver the address. As you know, he was formerly the Chief Justice of the Punjab and Haryana High Court. He was also formerly the Chief Justice of the Delhi High Court. In a previous lifetime, or should I say in the years gone by, he used to be a part-time lecturer at Delhi University Campus Law Center, from where he graduated with an LLB, where he got a gold medal, and then a 3-year LLM course where he stood first year upon year. So the standards of excellence that he set, it was no surprise that the intellectual property world declared him in 2007 as one of the top 50 people, most influential people in the world in this sphere. During his course as a senior advocate, he represented educational institutes, public sector undertakings, banks, financial institutes, and also corporates. So thank you so much for being with us, Honorable Justice A.K. Sikri, and for delivering this address.
Thank you, Shivani, and good morning to all of you. Let me tell you at the beginning itself that because of paucity of time, I'm avoiding the ritual of mentioning everybody's name as well. I had few things to say. In the first instance, when I was invited, I thought that what should I say here? Because I'm sitting in so-called appellate jurisdiction and hearing the appeals from COMPET nowadays. And one very significant case, we reserved judgment few days ago, and I'm writing that judgment, which takes care of, which would take care of some of the issues, thorny issues. Another case where we have 2 days ago, the arguments have started, so which will again go on. So while standing here, I had to decide that yes, I have to eschew those discussions because I can't disclose my mind as of now as to what is my view on those issues. Still, in spite of that, yes, I could muster some of the thoughts and thought that I'll speak on that. But let me tell you very frankly, 4 or 5 such aspects which I wanted to say are subsumed by the wonderful discourse of Dr. Singhvi. 1 or 2 other things which left are taken care of by Mr. Rajiv Kher and Mr. D.K. Sikri. So therefore, and third important problem before me is that I requested Mr. Ramji Srinivasan that I should be free positively by 11 o'clock because I have to travel from this place to another place which is 75 or 80 minutes away, and their conference has to start at 12 o'clock. I told them that yes, it may be late by a few minutes. They said yes, we will wait. But I think now even if I immediately start, I'm going to be late. So because of that reason, what I had prepared, still 8 or 10 pages, I'm not going to speak, but I'll only highlight only 1 or 2 aspects, maybe which are touched, but may not be in the manner in which I wanted to touch. No doubt about insofar as healthy competition in business is concerned, started with Adam Smith's discourse in 18th century when he talked of free market economy, etc., that laissez-faire economy, which started at that time with industrialization. And when we particularly talk about India and when we became independent, that we chose mixed economy. On the one hand, we had the communist or Marxist world, which was totally controlled economy, and Western world, which was still much free, but for whatever reasons, everybody knows, and I wanted to say something, but I am not stating and only making it a point, that yes, but naturally with this now from 1991-92 onwards, again we have fallen back to the, we have now traveling along with the world with globalized or liberalized economy. But this economy, when we had earlier license regime and quota regime and all those kinds of controls by the government, they have been wished away. But now free economy, but with regulation. And this regulated, regulation of the business has come in all ways. We had telecom, which was totally nationalized, but now it is open, but with Telecom Regulatory Authority. Which we had electricity, which was totally nationalized, but now we have electricity regulator. Likewise, in insurance, we have insurance regulator, although it is now privatization is there. And in this entire scenario, when we talk of ease of doing business or make in India, and we want to attract more FDI, where our Prime Minister is traveling to one country after other, and he's in Japan nowadays, again for this very purpose, and is sending this message time and again that we want that the atmosphere or the environment is conducive. That is the message which he is spreading in India, and therefore you come and invest and you will have reasonable returns. The Competition Act plays a very, very important role in this scenario. And what I want to say here is that Today, I think that is what is to be seen, that in every sphere and every field, wherever we decide, make decisions on judicial decisions as judges, it has the economic impact. Even if it is a case of you analyze why crimes take place, there are economic aspects of this. Law and economics is now a topic which is studied, and there's one Stephen Levitt, I don't know whether you have read his book on freakonomics, and he has come out with second book on super freakonomics also. And it is really, what he has given the name itself, freakonomics. He deals with, I read this book about 8-10 years ago, connection between law and crimes as well. Why crimes are also influenced by economic factors, and if those are taken care of, even the crime rate can come down. And we know that law of the land affects the economic behavior, and economic behavior generates need for laws. And this is, in this context, the competition law comes into picture. And if you study what is happening in some of the jurisdictions abroad, today when we talk of what is justice or jurisprudence on justice, we have various theories on justice, but nobody has thought till now about justice to be seen or located in economic analysis of the laws. And today, the thinkers, they are, the effort is going on in recent years to elaborate an overarching concept of justice on which the scholars are working, keeping in view two aspects in mind. One is judicial decision making, and other is place it on an objective basis. So therefore, when even the jurisprudence of justice is talked about, the economic analysis of law comes into being, whether a decision which is given by a particular judge, what is going to be the economic impact of that, which is very, very necessary. And here comes the role of CCI. Of course, as judges, when we decide the cases, and particularly when certain fundamental issues arise and come up for first time, we have to, and I have been telling you personally, it's not now for last 15, maybe I'm a commerce student, I'm a student of economics, so that may be subconsciously at the back of my mind, but now I realize what I was doing may be correct. I always think, whenever such a decision, what is going to be the impact? If you remember, even decision in Vodafone, which was given by Justice Kapadia, and after retirement, he said so very frankly, that look, at the back of my mind, when I was giving this decision was that how it is going to, if the decision would have been otherwise, how it would have adversely affected FDI in India. So therefore, these are some of the aspects, and when we take a particular decision, how it is going to affect the business, how it is going to affect the competition. Now, there are certain issues which are debated nowadays, and yes, issue of dominance, which was being argued, as we know that position of dominance per se is not bad. It is the abuse of that dominance which is bad. So which has to be kept in mind. But when it comes to, even if it is proved that yes, there was an abuse and it comes to, say, penalties, etc. Now, question is here, the only thing which I would say is that, and I'm happy that Mr. D.K. Sikri has himself accepted, and so therefore he is conscious about this fact, that it is the, and which was highlighted by Dr. Singhvi also, it is that balancing factor. Whether the purpose may be deterrent, yes, if somebody has abused the dominance position, or even if it is a cartelization or some merger, etc., in order to have the concentration of the market economy in that particular product, a person has to be punished, but then doctrine of proportionality has to be seen. Deterrent, of course, has to be there, but with deterrence, are we going to kill the industry itself, kill the business itself, or we are going to drive that business? So this is very, very important aspect which has to be kept in mind in each decision making. And at the end, I would only, what Mr. Rajiv K said was a very a very important point which he has made, is that it doesn't have to be a case-to-case approach. We have to have, as he said, sectoral guidelines of what I said, that let CCI has some kind of vision before it, what it wants to achieve, and then approach the issues on that basis. Of course, it has to be on case-to-case basis, but keeping in view that vision, which you may discuss, and after the framework, then what should be our approach in each case, I think should be the guiding factor. Thank you very much.
Justice Sikri, may I please request you to come forward to release the publication which has been put together by our publishing partner Manu Patra with the Competition Commission of India and the Competition Law Bar Association coming together. May I request all our kind guests at the stage to come together closely for a nice group photograph. Thank you so much. Ladies and gentlemen, this is the publication, the souvenir that has been put together to mark the 3rd International Competition Law Commission event here today. It's a great honor and privilege to have Honorable Justice Sikri release this for us. Thank you so much, sir. You were here with us in the last Competition Commission conference that we had, and you gave the valedictory address. It was a wonderful moment, and to have your continued support is hugely treasured. Thank you so much. May I please request Mr. Atul Dua, Honorary Secretary of the CLB Competition Law Bar Association, to deliver the vote of thanks. Atul is the senior partner with Saif Dua and Associates, and of course he is also a chartered accountant besides being a lawyer, and has been the honorary secretary ever since the inception of the CLBA. So please, ladies and gentlemen, I hand over to Atul.
Thank you, Shivani. She's been a constant at all the conferences, starting the first one in 2010, then 2012 and 2016. So we had an excellent speech by our chief guest, Justice A.K. Sikri. I share the same college and with Sri Ram College and then Campus Law Center with him, although much junior to him. Although I never got the gold medal than the scholarships he got. And that gold has much more value than the price of gold which we have these days. And now I'd like to thank Mr. Rajiv Kher, the best proxy counsel I've ever come across. Always supportive, and the last seminar we had on economics and competition law, he had graciously agreed to chair that as well. So always behind CLBA and supporting us. And I would say that Mr. D.K. Sikri, chairman of CCI, has been the most supportive till now for this conference. First time, as Shivani mentioned, the logo of CCI and CLB appears together on the souvenir. Thank you, sir, and we look forward to more such collaboration in the future. And finally, thanks to Dr. Abhishek Manu Singhvi. I sometimes have the pleasure of walking with him at the City Sports Complex, and always a pleasure listening to him. And that's actually more casual when we walk and talk together, and that's something I really enjoy. Thank you, sir. And of course, thanks to our president and our executive committee and the organizing committee, Ramji Srinivasan, who is the strength behind this conference, although he doesn't have the girth, but he's very strong. And I also like to thank member Compat, Mrs. Anita Kapoor, for gracing this occasion, members of CCI. I also see Mr. Dhanendra Kumar here, ex-chairman of CCI. Thank you, sir, and thanks foreign guests and all the legal fraternity, the corporates who are attending this seminar. And now, since we are running late, I'll ask Shivani to make the housekeeping announcements.
Thank you, Atul. And just quickly to say, there's coffee waiting for all of us, and followed by the two sessions. One will be here, of course. We have Justice Rajiv Sahai and Law chairing that session on compliance and due process. And then, of course, we have Mr. Rajiv Kher, who will be chairing the session on anti-competitive conduct. That will be on the first floor in Hall A and B. And so there will be parallel sessions that continue. Technical sessions in Hall A and B on the first floor. And for those of you who would like to know about the future and feel rather secure about absolutely relevant things like your own state of being, lunch will be served between 1 and 2 p.m. at the second floor of this very venue. And as you know, of course, in the evening, we'll have dinner at the Park Hotel at Aqua. So please enjoy the rest of the day, and rest assured there'll be lots to learn, share, and gain. Thank you very much. Thank you.